Hello everyone. Today we will gain some basic knowledge about contract laws through some basic multiple choice questions. So without wasting any time, let's start with it. The first question is consensus ad idem means A. General consensus, B. Meeting of minds upon the same thing in the same sense, C. Reaching an agreement, or D. Reaching of contract. The correct answer to this question is option B, that is consensus ad idem means meeting of minds upon the same thing in the same sense. The next question is a contract which is formed without the free consent of parties is what? Options are A. Valid contract, B. Illegal contract, C. Voidable contract, or D. Void ab initio. The correct answer to this question is option C, that is a contract which is formed without the free consent of parties is avoidable. Next question is if an agreement suffers from any uncertainty, it is dash. Options are A. Voidable, B. Void, C. Unenforceable, or D. Illegal. The correct answer to this question is option B, that is, if an agreement suffers from any uncertainty, it is void. The next question is all illegal agreements are fill in the blanks. Options are A. Void ab initio, B. Valid, C. Contingent, or D. Enforceable. The correct answer to this question is option A, that is, an illegal agreements are void ab initio. Question is, a promise to give money or money's worth upon the determination or assertment of a certain event is called dash. The options are A. Wagering agreement, B. Unlawful agreement, C. Illegal agreement, or D. Voidable agreement. The correct answer to this question is option A, that is, this type of agreement is known as wagering agreement. The next question is a contingent contract is a contract to do or not to do something if some event collateral to such contract dash. Options are A. Happens, B. Does not happen, C. Neither A nor B, or D. Either A or B. The correct answer to this question is option B. That means a contingent contract is a contract to do or not to do something if some event collateral to such contract does not happen. The next question is the phrase quantum merit literally means what? Options are A. As much as is earned, B. The fact in itself, C. A contract for the sale, or D. As much as is gained. The correct answer to this question is option A. That means the phrase quantum merit literally means as much as is earned. I is which of the following is the essential ingredient of contract of indemnity? The options are A. Contract to make good the loss, B. Loss must be caused to the indemnity holder, C. Loss may be caused by the promisor or any other person, D. All of the above. The correct answer to this question is option D, that is all of the above, which means that contract to make good the loss must be caused to the indemnity holder, and loss may be caused by the promisor or any other person are the three essentials of contract of indemnity. The next question is an agreement which is enforceable by law at the option of one party is which type of contract? Options are A. Valid contract, B. Void contract, C. Voidable contract, or D. Illegal contract. The correct answer to this question is option C, that is, an agreement which is enforceable by law at the option of one party is voidable contract. The next question is a gratuitous promise can be which of the following? Options are A. Be enforced, B. Not be enforced, C. be enforced in the court of law, or D, none of the above? The correct answer to this question is option B, that is, a gratuitous promise cannot be enforced by the court of law. The next question is, if A makes an offer to B on a particular day, then the offer can be revoked by A before which of the following? Options are A, B accepts the offer, B, A receives B's acceptance, C, B has posted the letter of acceptance, or D, reasonable period of time. The correct answer to this question is option C, that is, the offer can be revoked by A before B has posted the letter of acceptance, not after that. The next question is, the two types of breach are, options are A, the actual breach and the deemed breach, B, actual breach and conditional breach, C, actual breach and anticipatory breach, or D, actual breach and remedial breach. The correct answer to this question is option C, which means that the two types of breach in contract law are actual breach of contract and anticipatory breach of contract. The next question is, which of the following is not an essential of a valid contract? Options are A, adequate consideration, B, lawful object, or C, not barred by law. The correct answer to this question is option B, that is, lawful object is not an essential of a valid contract or an agreement. The next question is, a contract will still be a valid contract if it is which of the following? Options are A, opposed to public policy, B, in restraint of marriage, C, in restraint of trade, or D, without adequate consideration. The correct answer to this question is option D. That means a contract will still be a valid contract if it is without an adequate consideration.